Okay, Robert, the Perry conviction. This is the state of Texas. This is another BLM protest where a driver who happens to be in the military, I forget exactly what his position is, seems to take a wrong turn, gets swarmed by a crowd of angry protesters who apparently, I think this is uncontradicted evidence, sort of surround the car, start banging on the car. There's a guy, the person who ends up getting killed, I forget his name, who's carrying, I think it's an AR rifle. I mean, I think he's carrying a rifle on a sling. And
I think an AK-47, as I recall.
Are AK-47s actually legal in the States?
Oh yeah.
Okay, so I thought it was the AKs were illegal.
I'm not sure if it was legal that he had it.
Okay, the guy's got an AK, or so the chat's saying AK-47. Approaches the driver's side window and apparently points the barrel in the direction of the driver, who has a handgun, fires 3-4 times into the torso by his own admission, tries to neutralize the threat, and then speeds off. Then calls the police and then cooperates fully with the police. Guy dies. He gets charged with murder and gets convicted. Was it second-degree murder or was it first-degree murder? Oh, I'm going to forget that now. He gets convicted of murder. And now you got the Governor Perry, talking about coming in with a pardon. Robert, I try to look at this. Now, it went to trial. I didn't follow the entire trial as meaningfully as other stuff. I saw the expert testimony as to the trajectory, the speed of the vehicle, because people were initially saying this was deliberate, went in, sped in, shot it, and sped off, where it was clear from the expert testimony that the individual decelerated all the way up until the confrontation, then got swarmed, then, by his own testimony, got scared and feared for his life because his girlfriend was at the side of the car, and acted in self-defense in his own mind, took off, called the cops, cooperated with the cops. I try to listen to this and view it as if the guy who got killed this time was actually Rittenhouse, had it ended differently than Rittenhouse did. And it'll be a tough thing to reconcile in the minds of some who say the guy was just there to keep the peace and he saw a car that he thought was a threat. And so now, had it ended the other way, both could have claimed self-defense. What is your take on it, Robert?
Well, and I think you also read the issue that popped up with the police officer, right?
Yes, that we're going to get secondly. Apparently, exculpatory evidence was asked to be withheld. Let me just pull it up here. Was asked to be withheld from the grand jury. Now, this is from Marina Medvin, who says this is an affidavit I think the context is, I asked what the context was. I think it's a different investigation. But apparently, Fugit, being 18 years of age, yada, yada, lead investigating detective in the above referenced case. This was state of Texas versus Perry. Read the section 3, and then I'll go to the next one. It says, on more than one occasion, I was directed by Travis County Attorney's Office to remove exculpatory information that I had intended to present to the grand jury during my testimony. At that point, I specifically asked if there would be, quote, ramifications, end quote, if I did not do so. I was told by Assistant District Attorney Guillermo Gonzalez that he would ask the elected District Attorney, Jose Garza, what would happen if I refused to agree to the limitations I was being ordered to comply with. I was later sent an email simply reaffirming the exculpatory subjects that I was forbidden from mentioning during my testimony. Of my original 158 slide PowerPoint presentation, the presentation was reduced to 56 slides with almost all of the exculpatory evidence ordered removed. I felt like I did not have any other options but to comply with their orders. So that's what one of the investigators is claiming. Robert,
yeah, the lead investigator basically had recommended there not be prosecution, and believed that if the grand jury had been made aware of why he believed that this exculpatory information, they would have never even indicted Perry. And so you have a prosecutor who ignored the lead investigator because it was a very political case. The people that sort of took over Austin that night were on the left, and consequently, they wanted to prosecute this individual for shooting one of their leftist protesters, even though it was a leftist protester bearing a gun, and as video confirmed, he was pointing that weapon at Daniel Perry when Daniel Perry, in his mind, as he's expressed, defended himself by shooting back. So the issue is whether there was prosecutorial misconduct here as well in the proceedings. Now, the U.S. Supreme Court, in a case called Williams, said there's no federal constitutional requirement to provide exculpatory information to the grand jury, I think that case decision was wrong. I think it effectively eviscerated the independence of the grand jury, the impartiality of the grand jury, and cause, continuous problems. But that's partially why we're here, why these grand juries are no longer effective checks. Now, there's no certainty the grand jury wouldn't have indicted anyway, because this is Austin, Texas.
Well, and even had it been, let me rephrase this, had it not been presented to the grand jury, had there been prosecutorial misconduct, does that not get washed away? I presume the defendant brought up this exculpatory evidence in his defense, and then the jury still said no mas.
It's not clear what, to me at least, what was presented and what wasn't, what was made clear to the jury and what was not, and whether it was part of motions to dismiss or not. I'm not sure. But you have a combination of what appears to many people to be a classic self-defense case being prosecuted really for what appears to be only politically motivated reasons, the politics of the person, of the defendant, versus the politics of the alleged victim. And then on top of that, you have what appears to be at least some degree of prosecutorial malfeasance in what was presented to the grand jury and what was not, what was presented to the jury at trial and what was not. So there was a lot of public outrage at the verdict because a lot of people were surprised it was even prosecuted and assumed that an Austin jury would acquit when presented with the video evidence, the same evidence that led to the police officer to believe that there was no prosecution. There was not even probable cause of a crime. Yeah, you see him there pointing the weapon right at him in his car.
Yeah, but we learned our lessons from Rittenhouse. Even there, someone could say it's pointing down, but down at a car. I mean, the whole issue. This was the problem with Rittenhouse: is you get people on the streets with guns, and bad stuff is going to happen when regular citizens are playing cop. But when you see, the obvious material difference in this case versus Rittenhouse is. I don't even know if it's a difference, is that the car is getting swarmed by protesters, and that in and of itself is a threatening circumstance where they nobody knows what the heck is going on. This guy is not there to run over people, but everyone thinks that he is. And so they swarm the car. Dude in the car just took a wrong turn, getting swarmed.
In both cases are basically self-defense cases. Now, whether or not he was lawfully entitled to lift his gun at that point, that he saw something there, is open question. They tried to suggest that the driver, Daniel Perry, was engaged in provocative behavior. Provocation can remove the self-defense by saying he wasn't from Austin and he chose to go there and so on and so forth. But that was kind of what they tried to kind of argue in Rittenhouse, but ultimately were unsuccessful being able to mount that claim. But the real difference is simply the jury pool. One case, you had Kenosha, which is a politically split blue-collar community. In Austin, you have an overwhelmingly liberal jury pool. And what people are witnessing is the open, overt political weaponization of these communities to use the criminal laws to punish their political opponents. Now, Austin has been doing this for decades, in fact. They brought very questionable prosecutions against Congressman Thomas DeLay, prosecutions against Governor Rick Perry. So there's been multiple efforts in Austin to do this. It's just escalated with how political it now is. It used to at least have, a third of people in Austin that were on the other side politically. Now you got in the single digits, low, 10, 15% that are in the opposite party politically or truly or meaningfully independent or nonpartisan. And the left that's present is no longer the anti-state, pro free speech, old school left that used to exist in Austin. Used to, call Austin, keep Austin weird for that reason. The sort of the old country music cultural left, Molly Ivins kind of left, that Jim Hightower kind of left. That left is pretty much gone from Austin, as was shown in the Alex Jones civil proceedings. The juries are made up of partisan liberals who are eager, authoritarian liberals is the real difference. These are very pro-authority people, and they're happy to use their power for their political purposes. Now, there was a lot of calls immediately for Governor Abbott to pardon him In Texas, like many other states, the governor doesn't have an absolute right of pardoning. Instead, he appoints members to a board. The board has to first recommend pardoning. They can only recommend pardoning once there's been a criminal conviction. This too varies state by state, but in Texas, they can't pardon or recommend pardoning before then. And if a majority of the board recommends it, then and only then can Governor Abbott actually pardon Perry. The Governor Abbott came out publicly and said he has requested that the board give him that authority, and if it gives him that authority, he will in fact pardon Perry. Presumably, given that the governor appoints those members of the board will in fact recommend pardoning Perry, but we will see.
And I'll say this: from what I understand of the evidence, it is an outrage of a conviction. But even from some people say there is no leftist logic, but it's all hierarchy, not even double standards. The same lefties that said Rittenhouse should be guilty of murder because he shouldn't have shown up there with a rifle are now saying this guy should be convicted of murder because he shouldn't have been intimidated by a guy with a rifle that seems to be lifting it up a point. It's mutually incompatible and lacking any form of intellectual honesty or principles. But I saw enough of the trial that unless someone presents a compelling argument, it's an outrage, and we'll see what happens. But this is how you force a national divorce. What kind of person is going to want? You have gun rights, but if you use them, you're going to go to jail for life. I'll leave that. I would leave that jurisdiction. This is you're going to force people out of certain areas. You'll have a de facto national divorce.